Hello and welcome everyone. This is the mains crash course for 2021 for polity and governance. My name is Atish Mathur and we are going to start with our very first lecture today itself. So let's get ahead. Let me run you through some basic essentials of the course so that it's easy for all of us to understand and know exactly what it is that we're going to be doing. So the idea is that this is a course which is specifically designed for people who are appearing in the mains exam this year, which means this is going to be a fairly advanced course. So for those of you who are just starting out your preparation, you may find a lot of the concepts and a lot of the knowledge which is being imparted through this course to be slightly assumed. So don't worry, once you have read your basic textbooks, you should be fine. The objective of this course is a very simple one, is to make sure that 80% of all the questions that are asked in polity and governance in the 2021 means attempt come from this specific course. Now, this course is entirely free of cost. What I'm going to do is in this course, there are going to be two components. First, the conceptually and the theoretically tricky portions I'm going to discuss in the form of video lectures, which is one of the ones that you are watching right now. And second, of course, I'm going to give you handouts for things which are self-explanatory or are, in my opinion, not particularly very relevant as far as the exam is concerned. So, how do you get to download the PPTs or the handouts? All you've got to do is visit the website atishmathur.com, and on the home page itself, will you see a section called downloads? And on the downloads section itself, you will find a folder that says Mains 2021 Crash Course, and you will find a lot of the PDFs pertaining to this lecture available on the download section crash course tab itself. This is the website generally in case you want to read up a little bit more, and this is the telegram channel wherein I update all the happenings and current affairs and everything else almost on a daily basis. Now, here is the thing, and this is essentially how we would go about it. This is lecture number one, and this lecture is going to cover the first topic of the polity syllabus, wherein I'm going to discuss a few things in the video format, and I'm going to give you handouts for a specific set of few things. So we'll keep that in mind so that we are able to understand exactly what to expect and what not to expect from this course. So let's start right ahead. What you can see before you is essentially an entire layout of the polity syllabus as far as the mains GS paper 2 is concerned. You would know that this is the first theme or the first part of the syllabus. It's called the Indian Constitution, historical underpinnings, evolution, features, amendments, significant provisions, and basic structure, which means the first topic or the first theme in your main syllabus essentially is going to have six subtopics. Now, how do we decide? Do we need to do all the six in the right amount of detail? What is the depth that we require? For which we are going to conduct right now a previous year questions analysis from 2013 to 2020. And this is largely because 2013 is when the pattern had changed, and therefore we would be able to get a fair idea of the kind of questions that are asked. And on the basis of this pattern, we will identify and define what is called a boundary to decide what are the kind of topics that we should be preparing and what are the kind of topics that we should largely be leaving out. So let's start. So when we look at the previous year questions from the first topic, let us see the kind of questions that have been asked, and let us then also figure out why were they being asked and what do we learn out of them. This is extremely important, and this is an exercise you should carry out for all your GS and optional papers so that you can contain the depth of your preparation to the needs and demands of this exam. So let's start from 2013. Now, in the year 2013, the first question that was asked from this specific portion of the syllabus was discuss Section 66A of the IT Act, with reference to its alleged violation of Article 19 of the Constitution. Now, in 2013, this was massively in the news. It was so much in the news that anybody, whether they read the paper or not, would have not missed it. This was very mainstream. What you also must understand is this is before the Shreya Singhal judgment was delivered, which is why there was a scope of debate, there was a scope of argument, there was also a scope of understanding whether a specific portion of a specific act violates a specific fundamental right of the Constitution. Once the Supreme Court has already given a judgment, now listen to this extremely carefully. Once the Supreme Court has already delivered a judgment on the constitutionality of a provision, you will not get a question saying, was that judgment right or wrong? Or you will not get that question that says, is there a chance of analyzing the constitutionality of it? Once the Supreme Court has pronounced its judgment on the constitutionality of a provision with respect to a fundamental right, then you would get an impact question. Once that now the Supreme Court has pronounced this, what are the further implications of it? Right? So, like for example, with right to privacy, the question that came on right to privacy was, in light of Supreme Court's judgment on right to privacy, what are the further implications of that judgment? The question was not, do you think right to privacy is a fundamental right under 21 or not? Similarly, so if the judgment has been pronounced, you would mostly get an impact question. If the judgment has not been pronounced, then you would probably get an analysis question on should it or shouldn't it. So this is why it was asked. This was also in the news recently because despite the Supreme Court very clearly pronouncing Section 66A of the IT Act to be unconstitutional, there were several reports of cases being filed, FIRs being filed on this very specific provision. Now, this is not as much as a constitutionality issue as much as an implementation issue as to why has the Supreme Court judgment not been implemented in its spirit or not. I have discussed this in another YouTube video. I will link that video in the description on a series called Water Thought, where I've spoken about how Supreme Court judgments often don't get implemented, and Section 66A is not in isolation. So that's the first learning. The second learning is we've gotten a question from Article 19 because free speech is an ingredient, and free speech is often considered to be one of the key hallmarks on which the UPSC asks their questions. Then we look at the second question in 2013, where the question asked, the Supreme Court of India keeps a check on the arbitrary power of the Parliament in amending the Constitution. Discuss critically. So you would realize in most of these questions that we are talking about, a simple subdivision method of answer writing works perfectly well. So what is meant by a subdivision method? A subdivision method is breaking the question down into smaller sub questions and answering them in the form of headings, which automatically create the structure to your answer. Of course, the introduction and the conclusion don't have to be written in points or headings, but in this case, you could. So, for example, in this question, how would you write your answer? Your answer would be first, how can the parliament amend the constitution? What kind of a power does it enjoy? How has the Supreme Court kept a check on this Parliament's power? Fourth, was the Supreme Court right in doing so? Now, this is a standard theory question on 368 and basic structure. Now, I'd like to also inform you of a specific pedagogical approach. You see, basic structure is essentially the starting point of what is arguably called judicial supremacy, or basic structure is often questioned or criticized for opening the doors onto judicial activism. Now, there have been questions on the same before that starting from basic structure, examine the role of the Supreme Court in judicial activism to enhance the democracy of this country. So what I've done is questions on judicial activism and judicial adventurism. I've kept it exclusively in the topic for judiciary because you would have a larger set of examples and we would also look at it from a center state perspective. So here I will not be referring to judicial activism in a detail that is required. I will contextualize it, but judicial activism as a separate topic would be covered under judiciary itself. So again, a very simple theory question. Then in 2014, there was a question: what do you understand by the concept of freedom of speech and expression? Does it cover hate speech? And why do films in India stand on a slightly different plane from other forms of expression? Now, I must also tell you, in UPSC, the longer questions are always easier to answer because the demands of the question have been specifically explained in the question. So the question itself becomes your structure. Thirdly, when the question is so specific and so precise, you are able to very accurately answer the needs and demands of the question. Now, in 2014, because this was an election year, hate speech or censor issues or a new government coming in will always be the norm, no matter what year are we talking about, no matter who's coming into power or not. Of course, this is difficult to write because one tends to get a little political about it. I will, of course, discuss this. So, again, what you see is a question on Article 19 here and another question on Article 19 here, which thereby tells us that Article 19 is one of the most sought after areas from where UPSC can ask questions as far as rights and evolution of the Constitution is concerned. Now, why was this question asked? Of course, this was an election year. Second, there were, of course, some exceptionally objectionable speeches that were made, to which the Election Commission had also had sort of made some very strenuous remarks against. And this is also the same time where the leadership of the censor board in India was undergoing a change. Today, we've looked at the Cinematograph Act, which essentially undermines the powers of the censor board. So this again becomes a renewed issue, especially the films part, as far as our question is concerned. So an easy question, but a question that would require, of course, a more vivid approach. Now, 2015 discussed the possible factors that inhibit India from enacting for its citizens a uniform civil code as provided in Directive Principles of State Policy. Now, the reason this was asked in 2015 is because several cases of triple talaq had come to the fore, wherein people were undergoing triple talaq through a WhatsApp message or by writing a letter to each other, thereby undermining the very intent of why triple talaq was a part of Islamic jurisprudence, which again sparked off a larger debate as to why do we not have a uniform civil code. Again, this might seem like a current affairs question, but this is actually theory because no development has happened in and around uniform civil code. The arguments for and against still remain the same. The context may of course change from time to time. That is why I have written a consolidated note on Uniform Civil Code on my website, and I will link it below in the description box for you to read it. And it's a one pager that you can probably prepare and also use it for other areas of the exam as well. 2015, does the right to clean environment entail legal regulation on burning crackers? Discuss in light of Article 21 of the Constitution and judgments of the Supreme Court or the Apex Court in this regard. Now, this, of course, was also in the news extremely recently, where the Supreme Court said it is impossible to completely ban crackers. But of course, except for green crackers, which do not harm people and animals and are produced in an organized and a legal manner, those are the kind of crackers that we will allow. Everything else, of course, would be questionable and we would not allow. This was, of course, a massive issue in 2015, where the Supreme Court, for the first time, had sort of was about to deliver a judgment on banning crackers, which is why it was asked in 2015. I do not see very specifically a question on crackers to be repeated, so I don't think you have to prepare this again because it has already been asked once and also fairly recently. Now, when we look at 2016 onwards. This is a question which is this theory question, which of course will have a lot of current affairs context as examples. The question was, discuss each adjective attached to the word republic in the preamble. Are they defendable in the present circumstances? Now, the question might seem like something it's going to put you in a spot, but it is not. And of course, I have also attached a PDF of the notes on the preamble. I don't think it is relevant to teach you the preamble because it is too basic. So I've given you notes with examples. But the simplest way, the trick to answering questions like this is, so they're saying answer or analyze words attached to republic, which doesn't mean that you have to answer the word republic. Attached to republic. So sovereign, socialist, secular, democratic republic. Now, all you have to do is answer the sovereign, socialist, secular, democratic, and you have to answer, is India sovereign, is India socialist, is India secular, and is India democratic? Your basic explanation is India has its own version of what is meant by sovereignty, socialism, secularism, and democracy. So, when we say sovereignty, we talk about national interest and global good. So, you could give examples of India's position on death penalty, India's position on nuclear power, India's very recent stand on the conference of parties that happened in 20 in just a few days ago, COP26. You could further give examples on how India has taken a neutral stand when it comes to issues that were affecting countries such as Israel and Russia, because we wanted to propagate and promote national interest. So in each of these cases, India has done what was in its best interest and not essentially given into what is called substantial global pressure. So which is exactly how you would answer questions like that. Similarly, when we talk about socialism, you would talk about how India essentially was a very interventionist and a very active welfare state in our early years of independence, with thorough 5-year plans and dedicated government control and ownership in key industries. From there, we moved to a license permit Raj, and then 1991 globalization happened, where we're looking at the state's role as a regulator and a facilitator, with single window clearances, ease of doing business indices, higher FDI in key sectors, introducing new FDI in key sectors, promoting e-commerce, giving local production and linked incentives a boost. It's not that we're not doing enough for welfare, it's just that we are making sure that welfare and sustainability coexist. So that's our version of socialism. So you could then also talk about how MG Narega is one of the largest work schemes in the world. Ayushman Bharat is one of the largest health schemes in the world. Right to education has received phenomenal global recognition. So it's not that we are not socialist, we're socialist in our own ways. Similarly, when we talk about secularism, so we are an active secular state. Not only do we regulate religion on grounds of morality, we also do enough for the welfare of religion. So you could speak about, say, the government help the government managing key religious trusts such as the Sai Baba Mandir, or say the Tirupati temple, or the Vaishno Devi shrine, or the government having, say, an extensive minority affairs department, the government sponsoring and and interfering in education given to madrasas, the government having special schemes on those regards, the government providing subsidized flights and trains for religious journeys. So it's not that India hasn't done its version of secularism. At the same time, notions in secularism which seem to sort of violate the person, such as, say, triple talaq or santhara, have been and are also being examined by the court. So that's how you largely answer questions like, is the preamble justifiable? And your answer will always be, it is justifiable because India has its own version for it. Similarly, when we talk about, is India democracy, so you would say we're a parliamentary democracy, we're a quasi-federal democracy, and justify it on those grounds. So that's how you would answer it. You would essentially take up the broad issues which exist in current affairs, and on the basis of those broad issues, would you answer questions in this regard? Now, in 2016, again a theory question, what was held in the IR Coelho case? This is IR Coelho versus State of Tamil Nadu. In this context, can you say that judicial review is of key importance amongst the basic features of the Constitution? So, this is exactly what I was telling you, that when we look at basic structure basically sets up the platform for judicial review, which is often questioned as judicial activism on a case by case basis. So, theory question on it, but because it also has an implication to how the judiciary functions in the context of center state, I will take up judicial review and activism separately. I will, of course, discuss basic structure in a phenomenal amount of detail. So IR Coelho was basically that a retrospective application of Kesananda would be allowed in the sense that anything which is added to the ninth schedule, if it violates basic structure, could also be judicially reviewed, thereby enhancing the scope and powers of it. So that's largely the question, and of course, you would have to give some context to IR Coelho and why it happened. So it's again a theory question that almost everybody would have prepared in 2016. Now, in 2017, see, this is exactly again what I was telling you. Once the Supreme Court has pronounced a judgment on a fundamental right, you would largely get an implication or an impact based question. So the question was, examine the scope of fundamental rights in light of the latest judgment of the Supreme Court on the right to privacy, which is basically the Puttaswamy judgment, which also came out in 2017 itself. So was a landmark judgment. So once the Supreme Court has declared right to privacy is a fundamental right, what does that mean? What does that mean for body privacy, informational privacy, proprietary privacy, and so on and so forth? I'll be discussing this today. 2019 was a slightly off question, which was essentially on what can France learn from India's constitution's approach to secularism. This is again over a period of time because of certain developments that happened in France with respect to the burqa, with respect to the Charlie Hebdo movement. How are France and India fundamentally different? So a lot of students focused and got a little scared on them not knowing France's notions on secularism. All you have to do is answer dominantly on India's notions on secularism, and the ones that India very peculiarly has to herself will always be the differentiating factor. So I can understand this could have been a tough question, but again, you could still answer it in a larger context. Now, in 2019, in 2020, we didn't have a question on from this specific topic, but in 2019, the Parliament's power to amend the Constitution is a limited power, and it cannot be enlarged into an absolute power. In light of this statement, explain whether the Parliament under 368 can destroy the basic structure of the Constitution by expanding its basic power. The simple answer is no, it can't, because basic structure is not written in the Constitution. So if it's not written in the Constitution, how are you going to alter it? So there are only extra constitutional means through which you could sort of alter basic structure applications. And I'm going to come to that. The point I really wanted to make here in its entirety was that if you look at the kind of questions that are being asked, say in 2019, and you compare it with the question which was asked in 2013. If you see the 2013 question here, and if you see the 2019 question here, they're more or less the same thing with just enhanced applications, which makes it very, very interesting, extremely interesting for us to sort of, see that there is going to be a standard question on basic structure and the applications of it. Okay, so this is something we should have known. And on the basis of this, we are able to identify what I called the boundary to this topic. So, what is the boundary? When we look at specifically the kind of questions that can come from historical underpinnings. Of course, there have been several previous Government of India Acts, but it is the Government of India Act 1935 which has had a phenomenal impact on how the Constitution of India today looks like, right from establishing a federal court to, say, the lists such as reserved and transferred lists to powers given to the Governor General, to introducing diarchy at the center, to a method of parliamentary elections. We see a lot of it, and of course, notions of emergency as well. And a lot of this has an excellent impact on center state relations as well. So I've given you a handout on it. Please make sure you read that handout, you memorize it. I've given you the features, the limitations, the comparisons, and what is the resemblance of the modern day constitution to the 1935 one. So it is important. We must definitely do it. I've given you a handout for it. Please memorize that handout and please cover that handout from the drives that I've given you. Okay, and it's extremely important. Now, when we look at the evolution, of course, we're going to be doing the basic structure, we're going to be doing the analysis of it, and the relationship between fundamental rights and directive principles. For fundamental duties, again, I'm going to just give you a handout suggesting what are the additional fundamental duties we can have, recommendations of certain committees. I've also uploaded the handout on the drive. You can download it, memorize it, and you're good. As far as features is concerned, as you would see that there has not been a single question on the features of the Constitution, except for judicial review, which we will discuss in the context of the judiciary and to an extent center-state relations. So I don't particularly see for you to, focus on the features. However, if you've read a standard textbook and you would know the basic features of it's a written constitution, it's rigid yet flexible, provides for a quasi-federal state, you should definitely memorize those 5 6 points, and that is it. As far as amendments are concerned, we haven't seen a major constitutional amendment as such. The more recent ones have been on who gets the powers on deciding socioeconomic backward classes. We've seen amendments on limiting Anglo-Indian representations to the assemblies and the Lok Sabha. We've seen amendments on extending SC reservation to seats for the next tenure. We've basically seen those kind of amendments. The last significant amendment that really fundamentally gave a perspective to the way this country runs was actually the first 101st Amendment, which was GST. So when we look at amendments here, we'd largely be talking about amendments in the context of Article 368. Right now, this is something very important. The UPSC is never going to ask you your view on reservation. The UPSC is never going to ask you, is India a secular state or not? So all the controversies around religion and reservation, as far as paper 2 is concerned, should entirely be left out. In fact, the controversies around religion and reservation could largely be used in an essay on social issues, or the UPSC has asked questions on reservation to the account that how effective have national commissions of scheduled castes or scheduled tribes been to uplift the lives of people who come under these brackets. So I have not particularly seen a question on this, and I don't think you should prepare, which means UPSC's sweetheart or UPSC's favorite has been Articles 14, 19, and 21. Now, when we look at Article 14 fundamentally has a lot of implicit applications. Whether you look at LGBTQ, whether you look at decriminalization of adultery, when you look at transgender rights, it's fundamentally treating people unequally. And that sort of gets clubbed into to 19 and 21. And you do have specific issues that arise out of 19 and 21. And therefore, we must definitely prepare media, protest, internet in the context of the IT rules, and LGBTQIA with specific focus on transgenders because there have been developments on this front over the last year and a half or so. And basic structure in context with evolution should be done as a review and an analysis. And as I said, miscellaneous topics which I'm going to give you in the form of handouts, and I already have uploaded them, are with respect to the preamble, the meaning and the words of it, reforms to fundamental duties, and certain suggestions, and the relationship between rights and directive principles. See, the UPSC has already asked a question on 368. The UPSC has already asked a question on IR Coelho. Now, either the UPSC will ask a question on Keswananda Bharti, largely because the gentleman died very recently, or the question may also be on Minerva Mills as one of the most underrated yet an extremely significant development in the constitutional scheme of things of this country. So I've kept focus on this, and that's how I've identified a broad range of the topics that we should be covering in a larger ecosystem. All right, so let's keep that in mind. And now let's start ahead, and I'll just reset it. And this is essentially the orientation. This is essentially how we're going to prepare this. And then I'm going to start with the first lecture, which is on 368, which is going to be the second video, which is going to be 1.2. So keep watching it as a part of the playlist.